Hi, welcome to another episode of the Lawyer Society Legal Podcast. This episode is coming after a very long time because I'm not able to make regular episodes. As much as I do want to make regular episodes on Spotify and also on YouTube, I believe until this work helps me sustain myself, I think I will not be able to make regular episodes, but I will try to make or engage with the listeners as often as I can. Now, in today's episode, I felt I can discuss two of my recent articles published on the Lawyer Society website, and I will list the links down below in the description for you to check out. Now, this is regarding the new CRPC and IPC that has come into force from the 1st of July 2024. As I have already written in some of my old articles and also discussed in some of my podcast episodes and also on YouTube, that there is going to be a few interpretational confusions or developments which will take some time for the courts to settle in with the new laws, and that will be the case with the litigants also. If you are a practicing lawyer and if you are approaching the court and if you want to file any application under the CRPC, or if you want to register an FIR under the new laws, then you must be knowing a certain few things so that you can discuss with the police officers and point to them so that you get the FIR registered under the right laws, so that it doesn't end up in a situation where it gets quashed merely because it is registered under the wrong laws. So for this, you need to be reading section 531 of the Bnss, which is the new CRPC that has come into force. If you read section 531 subsection 2 clause A, so when you read this particular clause, it is clear that any pending appeal, application, trial, inquiry or investigation, any of these which is pending before the 1st of July 2024, that is the date when the new act comes into force, all of these will be continued under the CRPC of 1973. They will be disposed of in accordance with CRPC of 1973. So any FIR registered on or after the 1st of July 2024 will be registered under 173 of Bnss and not under section 154 of CRPC 1973. So you must know here that the offence will be governed by the date of occurrence of the offence. For instance, if the offence took place on the 20th of June 2024, then the IPC will be governing the offence. That is, the offence will be one which falls under the IPC provisions. For example, if it is murder, or if it is an assault, or if it is a rape, or if it is abetment to suicide, or whatever it is, it will come under the IPC. And if the offence has taken place on or after the 1st of July 2024, then the provisions of the new IPC, that is the Bnss, will be governing the offence as far as the offence, provisions regarding the offence goes. So, to put it simply, the FIR will be registered under section 173 of the new CRPC, that is the Bnss, but the offence might be one from the IPC which has been repealed. So it is the date of occurrence which matters. Now the questions that will come up in the coming days is regarding whether in a case of a continuous offence where the offence began when the IPC was in force, but many of the incidents in the offence have taken place after the IPC was revealed and the BNS has come into force, which of the laws will apply? So these are questions which will be answered by the courts, but as far as the offences which have a pinnable date, that is a specific date that you can fix as the date of occurrence goes, then the particular penal statute that was in force on the date of occurrence will be applicable. So this is as far as the first part of this episode goes. Now the second part, this part will be about a judgment from the Rajasthan High Court which was pronounced very recently on the 9th of this month. The cause title of this judgment is Krishna Joshi vs. State of Rajasthan. The case number is SB Criminal Miscellaneous Petition number 4285 of 2024. It was decided on the 9th of July 2024. Now as per this particular decision, if an FIR is registered under the CRPC, any trial that comes out of the FIR will be governed by the CRPC irrespective of when the trial begins. This, the court says, will be the right interpretation of section 531 subsection 2 clause A. It is surprising to me that the court has not looked at the provision wherein the particular provision gives a separate heading, a separate place for appeals for applications, trials, inquiry or investigation. So it means that they have given a separate heading for each of these stages, which indicates the fact that these stages are distinguished from one another, and any particular proceeding that is pending, that particular stage will be governed by the CRPC as if the Bnss hasn't come into force. That is, the particular stage will be governed by the law in which it began. Now, after the particular stage ends, suppose if the FIR was registered under the CRPC, the investigation was conducted under CRPC, then the investigation will proceed under CRPC. But when the charge sheet is filed, when the trial commences, so to speak, when the trial commences, if it is after the 1st of July 2024, then it is the Bnss which will govern the trial of such a case. Or if the trial took place under CRPC, but the appeal is filed after the 1st on or after the 1st of July 2024, then the appeal will be governed by the provisions of the new CRPC, that is the Bnss. So this is how I felt the particular clause under the new law must be interpreted. So obviously, to confirm this, we can look at how the courts took a view when the CRPC of 1973 repealed the CRPC of 1898, where section 484 provided for the repealing clause or the saving clause, as you can call it. So as per section 484, there was a similar clause wherein the different stages were given a separate header and they were given a distinguished position, so to speak. Now that was interpreted by a division bench of the Bombay High Court in the case of Janardhan Sarvotam Rao versus State of Maharashtra in the year 1976. The citation is 1976-78 Bombay Law Reports 380. This was also followed by another division bench, if I'm not wrong, that is also from a division bench, and the cause title is Shriyans Prasad Jain versus Shanti Prasad Jain, reported in 1977-79 Bombay Law Reports 394. In both of these cases, it has been said that any pending matter will be disposed of in accordance with the CRPC of 1898, but the subsequent stage will be governed by the CRPC of 1973. And the Bombay High Court, that is the division bench in the 1976 case that I have previously said, there it was noted that these particular stages were given a different heading. So they were the exact argument that I have put forth in this particular episode was discussed by the Bombay High Court in that particular case before they came to this conclusion. So it is surprising that the Rajasthan High Court has not taken the old cases into consideration. As I've already said, when we have an example from the 1970s, when this CRPC of 1973 came into force, the same principles, interpretations and the cases from those particular years can be used in interpreting the particular provisions from the Bnss that has come into force in this year. I hope you found this episode useful. Please do check out the links of those articles in the description, because through the links you will be able to get to these case laws and read my article on these issues. And I hope we can meet more often and I can engage with you as often as I want to with more and more of these legal episodes, so that we can have these continuous discussions on the new laws and also on various other legal issues that we will find interesting. Thank you. Until next time.